Welcome to a new episode of the Southeast Asia IPR SME Helpdesk video podcast. My name is Valentina Salmoiraghi. I'm the IP Business Advisor of the Helpdesk. Today we're going to discuss IP enforcement in Thailand. And on behalf of the Southeast Asia IPR SME Helpdesk, I would like to welcome our IP expert, Mr. Somboon Earterasarun, Director at Tilak & Gibbins in Jakarta. Thank you, Somboon, for joining us today.
No problem, my pleasure.
So, Somboon, to begin with, I would like to ask you one question. How does Thailand's IP legal framework compare to international standards?
Okay, I think in general, the Thailand enforcement pretty much compliance and up to the international standards. But there are some of the problems, like for example, the language, because all the documents and everything has to still be in Thai. So sometimes for the foreign IP owners, it could present some of the challenges and hurdles sometimes. But IP right can be enforced in Thailand quite effectively.
Okay, thank you. And which are the main avenues for IPR enforcement in Thailand? Would you like to briefly describe each of them?
Sure. We can categorize it to four main streams, I would say. First one, and this is tend to be the easiest part and the most effective one, and also the least cost effective, would be the custom measures. So it works especially in terms of import and export of the products across the border. What we do is that we should, whenever that we have a registered IP right in Thailand, we should deposit our certificates or instruments that we got in the countries with the customs office, and then whenever that there has been a suspected shipment either to come to Thailand or to be exported out of Thailand, then there will be intelligence from the custom office contacted to the local representative and asking if we would like to do something against that. So that has been proven to be very efficient way of enforcing the IP rights. That's the first one. The another avenues would be criminal actions, and obviously you can simply report the complaint to the police. Obviously you need some local guidance on that, simply because everything still has to be done in Thai. And criminal basis enforcement seems to be quite a successful one too, despite the fact that it's take a little bit longer time, and then it takes some time before you can investigate as to who are the infringers, what kind of actions that they are doing, how they are committing that infringing act, and where the goods are moving to. And the third avenues would be civil prosecutions. So you can actually file a complaint to the court for damages too. But this avenue seems to be a little bit lengthy and probably might not be suitable for the European SME, because in Thailand we don't have any things that call punitive damages as in the common laws in most of the countries in the European Union. So usually the damages that we got awarded from the court would not be able to compensate as to the real actual damage to the IP rights. So that's the third avenues. And the fourth avenues would be just simply to send a cease and desist letter. And this is again another very cost-effective way of the enforcement, and also this is a way that you can get things done and settle very quickly. But the success of these options depend solely on the infringers. I mean, if you're talking about a well-known infringers, this might not be working, but if you're talking about retailers or individuals company, it's proven to be quite a successful tools for enforcing the IP right in Thailand.
Okay, thank you. And in terms of pursuing administrative actions in Thailand, what is your experience in this type of actions?
Okay, usually administrative action is the way that we can report the case to the Department of Intellectual Property, asking them to help with the enforcement, even though this is going to be only administrative levels. So we cannot jail the infringers based on these administrative actions. But what happens and what is actually very effective in terms of practice is that usually when we report the case to the DIP or Department of Intellectual Property, they usually will summon both parties to come to have some kind of mediations, and the DIP will play the mediator role and to try to settle the dispute. And that has also been effective in many of the cases.
Okay, this is very interesting and also gives the broad range of options that are for European SMEs in relation to Thailand. A last question. In terms of criminal prosecution or civil litigation that you mentioned, which one in your opinion then bring the most satisfactory results when enforcing IP rights in Thailand?
I would pretty much say with my confidence that criminals sanctions or criminals proceedings work far better than the civils, simply because, like I said, in Thailand is the civil law countries. So for that, we don't have a punitive damages in our legal systems, especially for IP rights. And for that, usually the damages in the court that are awarded will not be playing the deterrent effect against the infringers. So what will work more against the infringers would be to jail them or to put a hefty fine against them. So for that, criminal actions work a lot better, and they are less cost consuming and time consuming.
Okay, and they actually, I mean, that they can really stop the infringer and the infringement activity.
Indeed.
Which is the one of the main aims, of course, for SMEs.
Exactly.
Okay, thank you very much. So with this, we wrap up our interview. Thank you very much, Somboon, for sharing your thoughts and also these valuable IP insights with us.
Thank you very much for having me.
So this video was brought to you by the Southeast Asia IPR SME Helpdesk. As a project co-funded by the European Union, we invite you to visit our website www.ipr-hub.eu, and where there are actually many interactive learning tools related to cross-cutting and industry-specific IP matters, available all free of charge for European SMEs looking to head to ASEAN region. See you in another video. Bye.